kind of rip right through these slides, but I really wanted to start with the big takeaway, and that is that you just have to read these rules changes. There are so many changes, and as always, the devil's in the details. So if you haven't taken an opportunity to read the rules, please do so. I think you will find the answers to most of your questions there. People have said, well, where do I find the rules? Well, if you don't have a new rule book, which the new 2015 rule books do contain rules changes, I tend to try to focus people's attention on what you can see from the court of iowacourts.gov. If you scroll to this place on the expedited civil actions and you click on that, you can see the following. You can see the two orders relating to the adoption of the rules. If you click here, you can see the actual expedited civil actions rule. The forms are there for you to download and to review as well. If you want to look at the discovery amendments, you go back to that first page and click on discovery amendments, and you'll get to this page, and you can pull those down as well. I believe Christy has already provided to everyone who has signed up for the webinar today copies of some, but not all, of these items. You have some of those with you, whether or not you've downloaded anything as well. First things first, the effective date is awfully important since we are now into January of 2015. There's two ways of looking at the effective date issue. This slide gives you one, and that is to say that all of the amendments are effective January 1 with these exceptions. Those are big exceptions, by the way. For example, the expedited civil actions rule applies only to cases that are filed after January 1, 2015, with one exception that we'll discuss. All of the initial disclosures and expert witness disclosures under 1.500 is an exception. Those rules, excuse me, don't apply to pending cases. They apply only to new cases as of 1/1/15. The timing provision in 1505 sub 1, discovery conference, expert discovery, and the civil trial setting conference rule, all of those apply only to new cases filed on or after 1/1/2015. Some clarifications. I've learned the hard way from doing these presentations that this is necessary. The committee proposed and the Iowa Supreme Court approved two different sets of rules changes. One of them is the ECA, which is the expedited civil actions rule, and also substantial amendments to the discovery rules. The discovery rule amendments apply to all civil actions, not just the ECA cases. Some people got the wrong idea on that. By the same token, when you are dealing with an ECA case, all discovery rules apply to the ECA cases except where the ECA rule provides otherwise. Now let's talk about expedited civil actions. Expedited civil actions are basically for money damage cases only. It's the only relief you can seek in an ECA. If you want more relief than just money, you have to stay out of ECA. ECA claims are $75,000 or less. The rule language is expressly designed to limit your recovery by one party or against one party to $75,000 or less. That $75,000 includes everything except costs and post-filing interest, not pre-filing interest, which would be incorporated within the $75,000. The committee made a decision at the outset with respect to what it was going to recommend to the court, that we had to give control over the destiny of a case to the plaintiff. It's the plaintiff who controls whether or not to file his or her case in the ECA rule. Once in, the plaintiff is bound by the $75,000 limit. More on that in a moment. There's only one way out. Well, I apologize. There's only two ways out of the ECA. One is for the defendant to file a compulsory, not permissive, but compulsory counterclaim, a value of which is in excess of $75,000. If the defendant does that, the court has the authority under the rule to remove the entire case from the ECA. The other way to get out of the ECA is for circumstances to change. That applies both to the plaintiff and to the defendant. The rule is silent on who can file a motion to remove the case from the ECA, but the rule makes it clear that it has to be a substantial change in circumstances after the filing. In other words, a defendant who is sued in an ECA case can't file a motion to remove the case from ECA simply upon the idea that this case, albeit about less than $75,000, is so important to that defendant that the case should go under the regular discovery and trial rules. There is no, quote, it's the principle of the thing, quote, exception under the ECA rule. Now, I told you that there was only one, that the ECA rule was effective January 1, 15. Parties may stipulate into the expedited civil action rule with or without the sealing. It shocked the committee members to find out that since these rules were published in the fall, that there literally have been several cases that have gone to trial under the new ECA rule because the parties on both sides of a pending lawsuit stipulated to do so. I'm anxious to hear how that's gone. Don't know yet. But going forward, now that we're in January, if you have a case that has been pending, you can, with stipulation by all parties, stipulate into the ECA. Now, anybody who thinks that they're going to get a faster trial date in that event, that's not going to happen. Court administration is working very hard to adjust their procedures and their calendars to deal with the influx of expedited civil actions. And it's going to take a while to get that right. If you have a pending case and you're looking to get an earlier trial date, don't use the ECA to accomplish that. If you have a pending case and you want to take advantage of the simpler discovery and trial process, and you're willing to be patient on your trial date, you can, if all parties stipulate, get into the expedited civil action rule. Here are some basic features about discovery with respect to expedited civil actions. The initial disclosures, because they are a new rule, they are required. The rest of the slide is self-explanatory, but note in red the reference to the word side. The rule refers in many instances not to party but to side. That's intentional. The design of the rule is to prevent two defendants who have similar interests from doubling up on the discovery matters just by being a separate party. So there's limits on discovery per side. You can see how many depositions can be taken. You can see that each party can be deposed, and then each side, not each party, but each side can depose up to 2 non-parties, and one of those can be an expert. With respect to summary judgment, the rule is very specific about what kinds of summary judgment arguments can be made in the ECA. The one that's missing is the if I give you all of the benefit of the doubt on all of the evidence, in other words, I give you the best version of the facts, you don't have a cause of action. That's not permitted under the ECA rule. The thinking behind that was that those motions are inconsistent with keeping to the early trial date. And the early trial date is 1 year, and the rule provides that the trial must occur within 1 year. Now, what that's probably going to mean, at least at the beginning, as we all patiently await this process with court administration, is that you will wind up getting a designated trial week with the case starting and ending in just 2 days. You could actually start as late as Thursday and still finish in your designated trial week. The ECA cases will actually bump standard civil cases. They won't bump anything else that has priorities, such as criminal matters and child custody matters. The jury is smaller. The timeline for less than unanimity in the jury deliberations is less. Please note the reference to joint jury instructions. What you're used to is each side giving the court their own set of jury instructions. The whole point of one joint set is to help the court get ready for a fast trial. Now, that doesn't mean that anybody has to waive their arguments about what the instructions should say. It's the party's obligation under the ECA rule to submit one set of joint jury instructions. That document can contain all of the alternate versions of, for example, instruction 13 that the parties can't agree upon, but it has to be in one document. As I indicated, the trial has to be completed in 2 days. If you're familiar with a chess clock, you're basically going to have 6 hours on each side in order to prevail at trial in 2 days. The committee spent a lot of time talking about whether or not to divide up that 6 hours for you by saying how much time there should be for jury selection. But we felt like that would be micromanaging the trial process and trying to fit everyone's case into one set of time rules. So instead, we concluded that it was best to just say you've got 6 hours, use your time wisely. I'm sure that there will be an adjustment period with respect to this, but you have to take responsibility for making sure that you have enough of your 6 hours left in order to do a good closing argument. Keep in mind that in busy counties, the judge that is presiding over your trial, if it starts on Wednesday, will have a full docket of matters assigned to him or her for Friday. It's not like you're going to be able to go into Friday because you didn't do a good job of apportioning your 6 hours. So keep in mind that you've got a limited amount of time. It has to last you for the whole case. Expedited civil actions can be to the jury or to the bench. One feature that we added to the rule was with regard to bench trials. The court has the ability to render a verdict just like a jury and get away from the delay that comes from preparing findings of fact and conclusions of law. If you go in that direction, then you still have to submit a set of jury instructions and verdict forms, just as if you had a jury trial. But the benefit for litigants is that if you go with a bench trial and with this option, then you'll get a decision right away as opposed to waiting several months for findings of fact and conclusions of law. One of the things that our committee did at the very outset of this process was to study what other states have done. And we spent a lot of time learning about other states' experiences because we felt that there was value in finding out what those experiences were. One of the things that we concluded was that almost all states that had adopted some form of expedited civil track basically eliminated juries or eliminated the standard traditional appellate route or imposed a wide variety of ADR. Our committee felt strongly that all of those were a mistake, and we were committed to finding a way to put together an expedited civil action rule that preserved the right to jury trial, that preserved the right to go to trial without having to jump through ADR hoops. And at the end of the day, whoever was disappointed with the result would have the right to go to a regular appeal. That's the system that we proposed, and that's the system that the Supreme Court approved and has published. And so either by order or local rule, you cannot be forced into any kind of ADR in the expedited civil action. Frankly, it's a matter of practicality. If you're going to have a jury trial at the end, although slightly different in form, and you want to get it done in a year, and you have to get all your discovery and trial prep done, you don't have time for the additional process of an ADR process. Special evidentiary rules with respect to expedited civil actions. There's a rule with respect to business records. If you give notice at least 90 days in advance of trial, the court may overrule objections based on authenticity and hearsay with respect to the admission of that document without testimony or certification from a custodian or other qualified witness. The objecting party has time, and I believe it's 30 days, in which to raise a question, a substantial question as to authenticity and trustworthiness. The point of this provision in the rule is to eliminate the time that gets used in dealing with most authentication, certification, and even some hearsay questions. I would expect that people will take advantage of this evidentiary rule in order to save time on their 6 hours. The other provision, special evidentiary rule, with respect to expedited civil actions is going to be much more controversial. It's going to be a challenge for everyone, and that is the health provider statement. A health provider who treated the claimant may provide a written statement on a form in lieu of testifying. This is the compromise that was necessary in order to make this rule work. It didn't make any sense to have expedited civil actions if the cost of litigation for plaintiffs in small cases still made taking the case nonsensical for counsel. What we've done with the healthcare provider statement is to change the burden, the financial burden with respect to treating physicians from the plaintiff to the defendant. If the doctor fills out the form in full, complies with the rule, then that statement will be provided to the jury, and the plaintiff does not have to bring the doctor either live or by evidentiary deposition to the trial. Now, that, in order to do that, the statement has to be provided 150 days before trial. Once that happens, the defendant can then choose whether or not to depose the doctor or to bring the doctor to trial, but the expense, of course, will be on the defendant, not on the plaintiff. Some miscellaneous matters with respect to expedited civil actions. There is a provision at the end of the expedited civil action rule that deals with claim preclusion and issue preclusion. One of the things that the committee was concerned about was the potential for abuse with respect to the ECA when you had an accident that resulted in multiple plaintiffs. We didn't want a lesser injured plaintiff to file and prosecute an ECA, get a result, and then have a more seriously injured plaintiff from the same accident use that jury verdict in the ECA to prosecute their claim in excess of $75,000 in the normal docket. Also, we spent a lot of time talking about whether or not the jury should be told about the $75,000 limit, and the committee's decision was that the jury would not be told about the $75,000 ceiling, and it will be interesting to see what people think of that. There are arguments in both directions. As a defense lawyer, I can tell you that I'm pleased that the jury will not be told about the $75,000 ceiling. Last point on this is a remark about court administration. The folks in court administration have a real tough assignment here because their trial dockets are already full. And just think about this. If you file an ECA right now, that case has got to go to trial in January 2016. Most of the trial dockets in most counties for July of 2016 are already full. Please be patient with court administration as they attempt to integrate the ECA into their existing trial calendars. It's probably going to take a year and a half for this to run smoothly. I see the question about the IMEs. We actually spent time talking about that, but the IME is not a treater, and so you won't be able to use the health provider statement for your IME. In other words, the ECA does not give you a shortcut on the IME. If you bring an IME, that's going to be your one expert. Type more, Scott, if you have any further questions on that, if that doesn't answer your question. Here's, I think this is the last slide under the ECA. This is, I did not make this. I wish I could claim credit for it. This is the slide that's in court administration's PowerPoint that's being used to train people across the state. I thought you would appreciate seeing this because it gives you in one place, one slide, kind of a schedule for your 1 year in the ECA. I'm going to provide to Christy the PowerPoint when the presentation's over, so that you can all get a copy of this. I'm going to move on now to the discovery rule amendments. If you haven't typed up your question about ECA, don't hesitate to still do it. I'll be watching for those, and I'm happy to go back and answer any questions that you have with respect to ECA as well as the discovery rule amendments. Again, just the same reminder, these amendments apply to all civil actions, not just the ECA. And really the big picture about these discovery rule amendments is that they constitute a very clear move towards the federal system with respect to disclosures, rather than the more traditional use of written discovery. There are some tweaks, and in order to save time, I'm going to focus on those tweaks if I can. The first thing we're going to talk about is the discovery conference, and the thing that you need to keep in mind is the fact that the first slide you're seeing under discovery has nothing to do with interrogatories, has nothing to do with requests for production or requests for admissions, and it certainly doesn't have anything to do with depositions. And that's because under the new system, which is effective for all cases filed on or after January 1 of 2015, you can't conduct that traditional discovery until you go through the discovery conference and the initial disclosure process. The rule provides that the discovery conference has to be held no later than 21 days after any defendant. Now, if A sues B, C, D, E, F, and G, as soon as one of them has appeared or answered, the clock starts ticking on that 21 days. And I know what you're all thinking, and I can tell you that we talked about it at length. If you wind up representing G, defendant G, and you get served 90 days after the lawsuit is filed, you're going to miss the discovery conference. I wish that we could have dealt with that problem, but our committee did not have an assignment from the court to deal with that service deadline that's in the rules. There's going to be some tension between this 21-day discovery conference and the rule that gives you 90 days to serve defendants. I think the court's going to have to deal with that at some point in time. But we concluded that if part of our goal, part of our marching order was to make litigation more efficient, we could not wait on the discovery conference to have it be 21 days after all defendants have answered or appeared. There is provision for a late arriving defendant to file a motion seeking a pretrial conference in order to deal with objections that they have to the results of the discovery conference. But that said, once somebody has answered or appeared, the plaintiff is responsible for getting the discovery conference set up within 21 days. Then, within 7 days after that discovery conference, new Form 2, Trial Scheduling and Discovery Plan, must be filed. Note that you can't put off your obligations to participate in the discovery conference or to conduct disclosures by filing some pre-answer motion. Now, one of the things that we did was to come up with a list of proceedings that would be exempt from the requirement of initial disclosures. I'm not going to read this list. A quick review of it will show you that virtually all of these exceptions make sense to you. and it's right in the rules, so all you have to do is read it. Here's a list of the things that need to be discussed at the discovery conference. And I need to share with you the anecdotal evidence that the committee had. I probably should have said this much earlier, but the committee was composed not only of private practice lawyers on both sides of the V, but district court judges, 2 law school professors, and even representatives from outside the practice of law. The court made it clear that they wanted us to focus on efficiencies, and the district court judges who were part of the committee made it clear unanimously that early conversation among parties and counsel about the specific case can lead to efficiencies and better operations with respect to the resolution of that case. And so the rule literally requires you to discuss these items at the discovery conference. The discovery plan has to consider these items in order to comply with the rule. In other words, you have to talk about ESI. You have to talk about what the issues exist in your case with respect to privilege or trial preparation protections. If there's a dispute, you can seek a pretrial conference to resolve those disputes. But the net result of your discovery conference is the preparation of the scheduling and discovery plan that have to be filed with the court. And I thought that it would be helpful to see this comment. The point that the court is making here is that it wants parties and counsel to confer early and cooperate in framing a discovery plan so that the case can proceed in an orderly fashion. Now let's go on to initial disclosures. If you have not practiced in federal court, well, brace yourself, because this will be new for you. If you have practiced in federal court and are familiar with initial disclosures, this will look very familiar. I'm going to focus on the changes between the federal system and the rule that is now in effect for cases that have been filed on or after January 1, 2015. Note for everyone, because I get this from a lot of people, disclosures are not the same as the standard identify all the people who have knowledge. Disclosures relate to what you as a party are going to use, both with respect to witnesses and documents, to support your claims or defenses. It's the limit. It is what is your case. You're required to disclose what your case is about with respect to witnesses and documents. Unlike the federal system, the new state rule opts to require production of the actual documents as opposed to just disclosing identity and location, because we concluded that for most cases the number of documents in typical state court civil cases are not so voluminous that we can't get them produced at the beginning. These additional items on this list and the following several slides are different from the federal system, so I want to talk about those. In Rule 1.500 sub 1, there has to be a computation by the plaintiff of each category of economic damages, not non-economic damages. The Gordon v. Noel interrogatory about itemizing and damages, etc., still exists. This doesn't change that, but at the initial disclosure stage, you have to provide computation of economic damages. Defendants who have insurance have to produce at the initial disclosure stage the declarations page, and if there's coverage in dispute, the policy itself has to be produced and the letters that relate to that dispute and or the coverage have to be produced. Now, I can envision, of course, that there's content in those letters that would be protected by work product, and there's nothing in the rule that requires disclosure of that. The rule is the rule would be satisfied by producing redacted letters, but the point is to disclose initially your declarations page and any coverage disputes. Not sure, I may have gone too far. Hang on here just a second. Okay. For personal injury cases, and the rule provides that that includes emotional distress claims, this is the additional list of items that must be generated during the initial disclosure stage. As you can see, it's the kind of stuff that generally gets produced pursuant to standard and traditional discovery. But here, under the new rule, you don't have to ask for this in order to get it. And if you're plaintiff, you don't have the right to wait to be asked. This is part of the process at the beginning of your lawsuit. You have to produce these things. Note that there has to be a signed patient waiver produced, but note also that the defendant has to provide notice when that waiver is being used, and they have to provide copies. In other words, we've tried to eliminate the disputes that arise from time to time about whether or not somebody asked to get copies of the medical records that the defendant obtained with the patient's waiver. It's just automatic now. Note at the bottom there, the default is electronic. If you want documents in non-electronic form and the other side prefers to give them to you electronically, they can require you to bear the cost of producing them in non-electronic fashion. If your case involves lost time or diminished earning capacity, here are the additional items that are relevant to your claim for purposes of initial disclosures. The same signed authorization provisions are present. Keep in mind that these 5-year limitations on the first 2 items at the top of this slide, that's just for disclosures. The fact that it's 5 years under the disclosures does not mean that the defendant cannot seek returns or employers older than 5 years in their standard discovery requests. This is just a limitation on what you have to produce in the initial disclosures. Finally, with respect to domestic relations cases, we came up with a list as well of items that have to be produced in the initial disclosures. I think these are all self-explanatory. If anybody has a question, let me know. Now, initial disclosures are due within 14 days after that 21-day discovery conference. So in other words, we're just over a month now from the date of the first answer or appearance. That 14 days can be shifted, excuse me, by either stipulation or court order, or by an objection in the discovery plan that initial disclosures are not appropriate. Just a second, please. Sorry about my voice. It's been a long week. Here's a provision for what happens to that late arriving defendant G. Remember him or her? If you're joined after the discovery conference or if you're served after the discovery conference, here you are. You get 30 days after that date in order to comply with the initial disclosures. So a practice point for you is that when you are a late arriving defendant, it is imperative that you get up to speed on the discovery conference and the plan and scheduling conference filing that has occurred so that you can decide whether or not you have any objections, because if you don't, your 30-day clock is ticking. If you've got problems with what was done without your participation, you need to move quickly for a pretrial conference to discuss those with the court and counsel. Now let's move on to expert disclosures. I need to check my time. We're running out quickly. It should be clear, but when you disclose on experts, you can't just disclose the name. You have to disclose the report, and the report has to contain all of these items. And it's right in the rules, so I'm not going to read those to you. For experts that are not required to provide a report, in other words, non-retained experts, the party that's going to call that witness has to comply with these two requirements. Now, the timing in almost all cases will be covered by that scheduling order that is developed during the discovery conference. But the defaults are here on this slide. Okay, now we're done with initial disclosures, and now we're going to talk about standard methods of discovery. Note, however, that there's new emphasis on aspirational goals for discovery. There's reference in the aspirational goals to expense and speed, and I can assure you that that's on purpose. The court is very serious about dealing with both expense and speed, and you're going to see an effort by the court to enforce that. Let's go straight to resolving disputes. This language has changed. If you're going to file a motion, you have to certify that you've made a good faith effort to resolve it. You have to show that you have spoken with the other side or tried to do so. The certification has to identify date and time. And telephone is acceptable, but email and letter are not acceptable. The language personally speak is in the rule. It's on purpose. It's the result of the anecdotal observations of the district court judges on the committee that we need to require lawyers to actually talk about the disputes before motions are filed. The scope of discovery has a really big change in it, and that's what I would call proportionality. The standard language under the scope of discovery rule has been amended to provide for proportionality with respect to discovery. In other words, the rule requires you to balance the burden and expense of responding to discovery against the likely benefit, considering these 5 factors. In other words, if it's a small case and it's not a complicated case, the scope of discovery should reflect that. The methods of discovery, witnesses, the rule is clear now that you can ask who the witnesses are, and you're not entitled to simply say, I'll tell you who the witnesses are 30 days before trial. I'm looking at a question here. Did I hear you to say that the discovery rules regarding mandatory disclosure are only applicable to cases filed after 1/1/2015? Yes, Randy, that's correct. All of the disclosure rules, which is what we've been spending time on until we move to discovery, all of those disclosure rules, both the initial disclosures and the expert disclosures, are all applicable only to cases filed on or after 1/1/2015. Let me know if that doesn't answer your question. We tried to fix something here at the bottom of this slide. One of the things that was brought to the committee's attention by non-members of the committee was A sues B and C. B conducts written discovery and gets answers from A, and then B settles. C has the right to rely upon the discovery conducted by B and to utilize the answers to that discovery, even though C never conducted any discovery. On the other hand, if C wants A to supplement that discovery response to B, they have to ask for it, because there is no automatic duty to supplement a response to a request by a party that's no longer in the case. Just a reminder on protective orders. In the protective orders, the new proportionality language is in that rule. So is the personally speak language. And the district court judges advocated for this. And now the rule under protective orders gives the court the opportunity to, among all the other remedies available, allocate expenses. In other words, distribute the pain as opposed to siding with just one. Discovery of experts. The disclosure has to happen first. You cannot take a deposition of an expert until after the expert's report has been produced. But if you want to take the deposition of an expert and that expert's deadline has passed with just the name being disclosed and not the report, you now have more ammunition to go to the court with to get the expert excluded, because you can't take that deposition without the report and your clock is ticking. We followed the relatively recent development in the federal rules by providing under the new rule that drafts of expert reports are not discoverable. I don't know if you have followed that debate over the last, I think it's 4 years in the federal system, but the federal system decided to eliminate the battle within the war with respect to expert witness draft reports. Now, under the state rule, the only things that you can talk to an expert about with respect to their communications with hiring counsel are matters relating to compensation, matters relating to facts and data provided, and communications relating to assumptions that the expert's been asked to make. All supplementation with respect to experts has to be accomplished no matter what, more than 30 days before trial. I thought that it would be helpful just to show you how the expert testimony at trial rule has been changed by the new rule. Note that the essence of the rule has not changed. It still provides that the expert's direct testimony may not be inconsistent with or go beyond the fair scope of the expert's previous disclosures. That part of the language has not changed. But Note what has been added. It's disclosures, it's deposition testimony, as opposed to answer to interrogatory. It has, and the disclosures include that report. All right, interrogatories must be provided in electronic format. Objections must be specific and signed by counsel. Now, we tried to fix something both with discovery and with request for production, and that is, what happens when you get an interrogatory or request for production, and part of it is fine, but part of it is objectionable. The court wanted to make clear that if you answer subject to an objection, you're not waiving the objection. And also, we wanted to make clear that if you're going to object, but then you're going to answer parts of the interrogatory, you need to say what part of it you are not answering, so that the other side knows whether there's something worth fighting about. The new rule provides that, well, it basically creates the opportunity for the bar and the court to generate pattern interrogatories, and if we do, and you use pattern interrogatories, you can exceed the 30 limit. If you're just using your own, then discrete subparts count. Here's the request for production slide. It's kind of the same thing that I just talked about. Again, you got to make sure that you're telling the other side what part of their request you are responding to, and or what part you're not, so that they can know whether or not you're withholding documents. Consequences for discovery. The motions to compel, the court now has the power under the new rule to grant a motion to compel without a hearing if no timely resistance is filed. And the rule has been changed to provide that the court shall order payment of fees and expenses even if the discovery is provided after the motion is filed and before the hearing. Here's a list of consequences that arise out of failure to comply with the initial disclosures, with the expert disclosures, or pretrial disclosures. Clearly, you don't want any of these things to happen to you. Depositions. We made a couple of changes in objections and instructions, and the court adopted this. Everybody's heard about the cases in federal court that have resulted in sanctions for lawyers who have gone beyond stating their objections. This rule adoption seems to be going in that direction. You have to state your objection, but you have to state it without argument and without suggestion. The rule now provides clearly that you can instruct not to answer only on 3 grounds. One is to preserve privilege. One is to enforce an existing protection that's already been ordered, or to present a motion under 1.708 sub 2. The last one is problematic. You have to deal with, that's a jumping off moment. If you're representing a party or a witness at a deposition and you believe that the questions are so bad that instruction not to answer is appropriate, you can do that, but only in order to adjourn the deposition, in order to present a motion under 1708 to protect the witness from those questions. So don't instruct to answer for the 3rd reason unless you're willing to actually file the motion. I see a question. If you're dealing with a pro se defendant, how does providing electronic word processing format work from a practical standpoint? Darn good questions, Chris. All I can tell you is that that's what the rule provides, and I must confess I don't know what the separate provisions in the practice manual are for pro se defendants, but there is no exception under the rule of civil procedure for pro se defendants to that language about electronic word processing format, and I don't know what will happen on that. But it's a good question, and I'm gonna bring that one up to the committee and see what we come up with. Thanks, Chris. I think this is the last slide, and it better be because I'm out of time. This is the changes that are made to the civil trial setting conference. Again, let me go back to the very beginning where I talked about reading the rules. If you've got the new West book, you'll see the new rules right in there, but the problem with that is that you'll see the current version, especially with these discovery changes. What you won't see is a red line. On the other hand, if you go back to iowacourts.gov and you go online and you pull down the discovery rule amendments, you will get a red line document, and that will show you exactly where the amendments have occurred. I think that's a priceless document for you to have if you want to get caught up with this process. I think that's pretty much all I've got for you. I'm willing to stay as long as Christy will let me. My clock says it's to 12:58. If other people want to type questions, I'd be happy to try to answer them. Otherwise, I appreciate you all coming on, and I wish you the best with adjusting to the new rules.